Hello, good day. My name is Deji Olatoye. You are welcome to the inaugural webinar of Creative Africa Nexus KNEX program. This webinar will be the first in a series that is associated newsletter for KNEX. Before we start, I'd like to introduce the organization that brought us here today itself. I will introduce the topic. And following that, let's know who our speaker for today is going to be. As I said, my name is Deji Olatoye. I'm a partner of the Creative Africa Nexus. It's a program that was developed by Afrexim to facilitate the development and growth of the creative and cultural industries in Africa and the diaspora. The program provides a range of financing and non-financing instruments and interventions aimed at supporting trade and investment in Africa's creative sector. So this is obviously one of the non-financing initiatives, in support. And as part of that is what we call the KNEX Book Factory that was launched in November last year, Cairo, during the Inter-African Trade Fair. This webinar is part of that Book Factory initiative. Book Factory initiative has a newsletter that is aimed to educate and promote sustainable business practices within the African publishing industry through three initiatives: a Pan-African annual writing workshop, a publisher's prize for African publishers, and a business newsletter for stakeholders in the African publishing industry. So this webinar is part of that newsletter. And so that's it about this webinar. So that means besides this, you should be expecting regularly webinars like this, and of course the newsletter that will be circulated across the African creative sector in due course. So the topic that we have for today is importance of intellectual property rights for creatives in the publishing industry. That's our inaugural topic for this webinar series. The important thing is that we want to draw on the pool of knowledge that Africa has developed either at home or across the diaspora, and to bring people who have done a whole lot of work and looking at the issues. And so for us, we are very happy today to, it's a fair heavyweight in the sector, Ms. Victoria, who is a doctoral researcher at Queen Mary University, that's of University of London. She's an intellectual property lawyer with project management experience with the United Nations through the WIPO, and sharing the vision to achieve economic prosperity in Africa through creativity, innovation, and Victoria, active youth engagement and development in Africa. She is the founder of a thriving non-governmental organization in Africa, My Intellectual Property Law Guide, MIPLG. And she's also the founding patron for the National IP body for tertiary institutions in Nigeria, which is called the Nigerian Intellectual Property Club.
Thank you very much, Mr. Deji, for that wonderful introduction. At some point, I was wondering if it was me you are speaking of. Thank you so much.
I'd like to start off with something. I'd like to say, I found out that your doctoral research is on a topic that is also very relevant to this. It brings aspects of intellectual property in the context of Africa agreement that was signed a couple of years ago. So what specific to the publishing industry would you say your research have found so far? Key things to just get us going.
Thank you very much, Mr. Deji, again. I think before I proceed, I would like to say a very big thank you to KNEX Book Factory for this wonderful opportunity. I would also want to say a big thank you to the director of the World Intellectual Property Organization, Dr. Oluwatobiloba Modi, who invited me to represent him at this webinar and sharing my little knowledge with you on the topic. As you rightly said, Mr. Deji, my research is on the African Continental Free Trade Area, but specifically on performers' rights under the framework. However, I would say that in relation to the publishing industry, although there has not been in the IP protocol a set out provision on publishers as such, we have in the protocol under Article 11 a general provision or general provisions on copyright and related rights, from which we could make certain inferences or draw certain inferences on implications for the publishing industry. Now, what we can see at this point, obviously, there's still a lot of work going on under the AFTA and the protocols, including the IP protocol to the AFTA. But we can see that it would appear that the African Union would want to, maybe not a cooperation framework, in which case you don't have strict provisions, but you have what could be directives, to member states. And from what we currently have in the protocol, there is definitely the direction that copyright and related rights should be protected under the various member states. There has been provisions on research, provisions on adopting the Beijing Treaty in making available copyright materials for the visually impaired. There are provisions on taking into account rapid technical developments in relation to the use of copyrights and copyrighted works. Obviously, there's also some provision on facilitating cross-border flow of educational and cultural materials, in which, of course, our books and other publications fall under. So what I can say is that generally there is some framework under which AFTA, through which member states of the African Union can cooperate and exchange materials in a healthy copyright environment.
Thank you very much, Ms. Onyagba. For the course of your research, which may still take a couple of years, we'll be able to bring you back to see what you further found out, especially in relation to publishing and the book industry. So let's kick off properly now. We are here to discuss broadly intellectual property, but specific to the publishing and the book industry. I'd like to kick off by saying, can you give us an overview of intellectual property rights? And we have like 10 minutes to do this. If you have any follow-up question, we should be able to do that. So I want you to look at some issues in terms of the overview of intellectual property. Explain to us what intellectual property are, different forms, and the importance specific to publishing industry. And we want you to contextualize it within the African landscape itself. And in doing this, I'd imagine you also want to bear in mind the business model of the publishing and the book industry. You have primary rights and revenue model that authors get. But of course, you also have secondary and ancillary rights, such as translation from the original language. You may also put in some other media. So we now have ebooks, we have about the AFTA protocol for the visually impaired. I guess that also goes to that. So we want you to look at all of it. And also there could be options for. So essentially people tend to focus on copyrights, when it comes to publishing. So we want you to look at how all of the other rights will also, along those lines.
Thank you very much, Deji. I think I would start with saying that the issue of intellectual property rights, and particularly in the publishing industry, is not something that we can conclusively canvass in 1 hour or less, so I'll do my best to highlight a few areas, but it's just so that we are aware that this is not a conclusive discussion on IP in the publishing industry. Generally, intellectual property refers to the creations of the mind. And so at every point in time, we want to be able to reward the hard work, to reward the efforts of creatives, of innovators who give to the society what they create through their intellect. There are a lot of justifications and reasons why we should have IP protection, but I would just say that one of the major ones is that it's some kind of reward to the creator or to the inventor. And so we want to make sure that the society continues to thrive. And the only way we can do that is if the government, if the people can be protected, or they can have good frameworks under which they are able to exploit the materials which create with their minds for either, and well, particularly for economic value. Now, there are certain kinds of intellectual property rights. I will not go into all of them, but for the purposes of the publishing industry, I would mention probably 3 that would be relevant to us. The first one is copyright. And as you rightly mentioned, when we speak of the publishing industry, there is a lot of focus on copyright, and rightly so. There are also certain kinds of rights like trademarks, which are also relevant for the publishing industry. There are other ones like trade secrets and or confidential information, depending on how you take a look at it. And sometimes even designs come in. Now, I would speak to copyright last because copyright has more impact on us, but I would mention trademarks first. So when you speak of trademarks, simply put, you're talking about whatever mark or symbol or insignia, whatever it is that your business is recognized by. So anything that distinguishes your business and or services from those of the others in the industry or in the market is your trademark. Now, trademarks are registered, right? You have marks rights that you acquire only by registration. And in Africa, you register in the IP offices. When you register these marks, you have, as long as you continue to renew your payments, as long as you continue to use the marks in the markets, you could have an indefinite right to use that mark for as long as your business subsists. These rights that you have are, I like to say that you should see them as property rights as well, because you are able to commercialize these rights, including your trademark. So, for example, the Canex Book Factory, I see your logo, beautiful. That is an example of a trademark. Okay, trademarks for publishing industries go a long way in the branding of the publishing company, because you want to stand out when you put out your works. Unfortunately, in Africa, we haven't done a lot in terms of publishing, and this is not really an African problem. I think it's a general problem for the publishing industry. You don't always know the names of the publishers. You probably know the name of the author, you know the work, but it only takes a certain level of interest to know who the publishers are. And many a time, the publishers are the ones that have the copyrights in their work. So trademarks it's a way that you can, it's a tool that helps you in the branding. It's not just trademark that you need as a publishing company, but it is an important tool in your branding. The other one is the confidential rights or trade secrets. I'm mentioning it in relation to the publishing industry because these are created in certain jurisdictions, they are statutory. In some other places, it could be common law. And they arise out of a legally binding relationship. Okay. And in the publishing industry, that relationship is created between the author and the publisher. And so once you get into that interaction, once you come into a point where you have signed, even before you sign, once there is an intention to create a publisher author relationship and information has been received by the publisher, you are bound, by confidentiality. And so many a time you have issues between authors and publishers because information has passed from one hand to the other, and then such information has been made public or not properly managed. There are other things like in terms of trade secrets, like your data, the data that you use as a publishing industry. It could be the list of your distributors. It could be people that freelance for you on certain different positions in your company. Information that is relevant to your business, such that if it goes out, is likely to hamper maybe integrity or also cause you some damage. So these are some of the things that you find under trade secrets. So now the most important one, which is the copyright. Copyright is a legal concept that describes the right of an author, a bundle of rights which is given to an author. We say a bundle of rights because copyrights can be quite complex. A tree that has a good number of branches. And some of the things to know is that with copyrights, you're being given those bundle of rights for a limited period. In Africa, most countries, because most African countries are now members of the Berne Convention, they are bound to protect copyrights of authors for the lifetime of the author plus 50 years as a minimum. So in many countries, that is what you have. In countries like Nigeria, you have the lifetime of the author plus 70 years, which means that the author has the copyrights in their works on the face of it for that period of time. However, when there are more than one person who have authored the work, it spans until the last surviving author. So the lifetime of all the authors, and then 70 years after the death of the last surviving author. This is in terms of duration. And what is it that we give to them? We give them two kinds of rights, the economic rights and then the moral rights. The moral rights is the right that they have to be attributed to their work, or the rights that they have not, the rights they have in their work to ensure that their work is not mutilated. So they have the right to protect the integrity of the work that they've put out. But the economic rights, which is where you usually have a good number of issues, is where they're able to maximize economically the work that they have put out. And this includes right of reproduction, it includes right of distribution, translation. Now you can start seeing where the publishers come in, because at the point where you want to publish and you enter into a publishing relationship, you're assigning your right to reproduction and in many cases distribution to the publisher. Now, for a work to qualify for copyright, it has to be original. And original has been interpreted to mean a lot of things. It just means that the form of expression of that idea, mind you, copyright does not protect an idea, it protects the expression of the idea. And that expression must have emanated from your independent intellectual contribution to that work. With the relationship that we have, publishers are allowed to enter into, and please, Mr. Deji, let me just check in with you at this point. Do you want me to give clear publisher author copyright relationships at this point, or is it a question for later?
Yes, we would, because once you close up, maybe in the next minute or so on this, we are actually going to go to challenges, and then you can then deal with those nitty-gritty.
Okay, great. So I think what I would do then is wrap it up at this point to say, in copyright relationship, on the face of it, the right belongs to the author. But what we would see going a bit deeper in this conversation is that those rights have to be transferred from the author to the publisher for the value chain to actually work and for the business models in the publishing industry to actually work. What makes a successful publisher would then depend on how these rights are being managed. So I think I would close it at that. Thank you very much, Mr. Deji.
Thank you very much. Thank you very much. Yes, I guess you have started talking about it, because we want to now talk about the challenges. And challenges means that we now begin to look at the practical issues, in terms of relationship between author and publisher. We also look at, again, the business model. So, for example, I'm aware part of what some people are talking, even within the level of earnings, is also how to actually properly finance and monetize proceeds from, and monetize this asset, commercialize it. They are talking about how can you have IP receivables be securitized, and of course, the meaning of securitization is that you need to secure that pipeline. You need to be sure that people get their proceeds so that they can pay back whatever forward financing had gotten before that. So, talk to us about the challenges of protecting intellectual property in Africa generally. What are the challenges? Then look at the specific issues of practical workings of the industry relationship between authors and publishers. Also, the ability to get finance and all of that. So what are those practical things? And then look at the institutions that are core to this protection. You already mentioned the IP office, the different forms of right across countries. And also the role of industry network, collecting societies, so what used to be known as collective society was now known as collective management organizations. And also in the case of securitization, say for example in the place like Nigeria, and I can't recall if Kenya also has registries. Tell us about these practical challenges.
Thank you very much, Mr. Deji. Everything that has been outlined, I promise, I'm not sure I can cover in 10 minutes.
I know, just do your best.
Yes, I'll do my best. I would say that the challenges for the publishing there are certain aspects of it, of course, that are peculiar to Africa, but generally, we see the same issues arise even beyond Africa. And the first part of it is obviously on the grant of the rights, and the rights specification. At the point when we are entering into the publishing agreement, what is the author accepting? What is the author giving off? What is the publishing industry receiving? What can they make of what they are receiving? So this is a crucial point, the grant of rights and the specifications of the rights. Now, obviously, the relationship is a license many of the time. So what you have is the author granting or entering into an exclusive or non-exclusive license. Now, an exclusive license is that the publisher has the exclusive right, not the sole right is different, the exclusive right to exploit the economic benefits which they would be receiving from that contract. Non-exclusive means that, for example, the author could enter into similar relationship with another publisher. But do our publishing companies know when an exclusive right is needed or when a non-exclusive right could be dealt with and how to deal with it? Answer is, for some of us, yes. For some of our publishing companies, yes, they do know that. But for some others, no. I've mentioned now the exclusive and non-exclusive. Other things could relate to what kind of rights are you giving off. As an author, are you giving just the right to reproduction plus the right to distribution? Bearing in mind that a publishing company would, in many cases, require the distribution rights to be able to monetize publishing relationship. Other things like, what is the limit? Do we give them publishing rights, reproduction rights for just hard copy or paper covers? Are we also in that agreement giving them the right to produce or reproduce digitally? So these are some of the contents of the agreement that usually raises a whole lot of issues. Now, in many legal frameworks, the publisher would be allowed to publish in other forms, so audio or even like digital versions. But then certain other territories may require an explicit or express contractual relationship between the author and the publisher. Sometimes the publisher forgets to request these things in detail. And then they work under the assumption that getting a reproduction right includes the right to reproduce digitally. But that is a completely different right of the author. And then when they go ahead to reproduce digitally, the author comes back expecting to get some kind of remuneration. Issues come up, and then we have falling out in the industry. Another thing is the ability of both author and the publisher to critically analyze the commercial value of the relationship which they may be entering into. Now, in Africa, a big problem that we have is that most times our authors approach the publishing company personally. We haven't really built the author agents business a lot in Africa. And the agents are usually those that have all the IP knowledge, the IP technical know-how really of what the author needs and how to navigate these legal barriers here and there. But our authors just want to get their work published and get some money for it. And so when they reach out to the publishing companies, the publishing companies know that this author really does not know a lot. And so they just give you some document and tell you to read and sign. You think, okay, well, they could give you some huge sum of money. You think all is well, but sometimes it results in ripping them off. So what we would get is that many a time we have work for hire situations where our authors receive a one-off payment, and that is it. But what happens to the subsidiary rights that happen is not your copyright relationship in publishing does not end with the work being published and distributed. There are rights that are ancillary or even subsidiary, after the publishing has been done. And because our authors are really not aware, every other benefits accrues to the publisher, and then the authors get that one-off payment, and that is it. And this is where the CMOs come in. So sometimes it will be good, even if the authors do not have the agent, it will be good to get involved in the collective management organizations, because now the collective management organizations are also, they work not just with the author, they also work with the publishing company, because they are the intermediary that connects the author to both the publishing company and then the final consumer. I wouldn't go into the complexities of the collective management organizations, but I will just say that it is relevant, especially if an author decides to go beyond an agreement, a work for hire agreement, and looking for royalties, in which case you're saying, I want a percentage of what accrues from not just the net sales, but even like the subsidiary rights that would come up. Now, what are some of the subsidiary rights? It means even like rights to televise, to produce further series. There are just a whole lot of things that come after that, to be fair. And this is where your IP knowledge comes in and how you can monetize it comes in. How about like things like the commissioned works? This is another area where we have a lot of issues in the industry, because in that author publisher relationship, the value chain starts from the author and then it ends at the final consumer. But between the author and the final consumer, there are a lot of rights that are generated. Now, in one work, in a book, for example, you have the author's rights. The author has the rights in the work, so in the work that they have put out, or even in the manuscript that they have submitted. The publisher sometimes acquires copyrights from the author. But aside that right, there is also what we know as copyright in the published work, right? In that edition that the publisher has put out, the publisher usually has the copyright in that. But how about the pictures, the artwork that this work embodies? There could be commissioned works there, in which case copyright may belong to other people. And now there has to be an understanding between the author and the publisher. Who is responsible for acquiring the copyright or the license to use these artworks, for example, in the work? Many a time, the publishers would want the author to deal with that. So you go and get the license for whatever you want to impute here. But if you have an agent as an author, if you know what you're really looking for and how to avoid this, you need to come to a good terms with them, where you really expect the publisher to go ahead in the course of editing and putting the work together. They should get the rights to these other works that the final work would embody. Another thing is issues on delivery and publication dates. I won't go into that right now. Acceptability as well. Acceptability is usually a problem where, so far we've been speaking of relationships where the author has reached out to the publisher. There are also situations where the publisher reaches out to the author to say, do this work for us, so they're basically going to pay that author either a one-off payment or still based on royalties. But then the problem comes in as to where the document or the manuscript is not accepted by the publisher. And then this is where the IP knowledge comes in. Publishers would want to avoid doing a one-off or like an advance payment of over 50% when they have not received manuscript and things like that. The other crucial thing I'll mention is in terms of warranties and indemnities between author and publisher. And of course, also between the publisher and the distribution companies that the publisher would be working with. And between the distribution down to the wholesalers, the retailers. So in this value chain, there's a lot of warranties and indemnities that'll be going in. But a publishing industry or a publishing company wants to make sure that they have at least 4 kinds of indemnities from the author. And the first one is that the author has to affirm that he is free to enter into this contractual relationship in the first place, which means that there is not an existing relationship, contract with another publisher somewhere else. The second one is that you have to promise, so you have to get the author to promise you that the work is original and that it belongs to him. In other words, he has not copied this work or plagiarized it. The third one is that you want him to provide materials that do not have third-party encumbrance or third-party problems with them. So if he has put in artworks in the manuscript, he has to confirm, he has to, promise that these works, either that he has the license to use them or that they are free of copyright. And then the last one is that, and this will depend on what jurisdiction you find yourself in, you want to make sure that you don't publish something and maybe the government is coming after you or people are coming after you for maybe libel or misrepresentation, slander, and things like that. I know that I have spent some good time trying to speak on some of these things.
Yeah.
Yes, I know I'm time bound, to be fair. Mr. Deji?
Yes, you've actually started, I mean, the good thing is that even when you go over time, that means no waste of time, right? And what I was going to go to next, as the last major issue, and then we're going to recap, is then to take us through the process for protecting intellectual property rights. We know there are different forms, but we have said, look, the main one that pertains to the publishing industry is usually the copyright. And that's why I was happy when you are going into the issues of even dealing with contractual issues and all of that, because that's the starting point, and then before we then talk about registration. So try and take us through the process for copyright, and if you can mention for trademark, because I think it's also very important to publishing industry. So if I want to secure my copyright as an author today, or if I'm a publisher who wants to be publishing authors, what are those steps that we need to take? And if you can do this in like 5 minutes, that would be great.
Thank you, Mr. Deji. So I would thank you. The copyright framework, unlike the trademarks and other kinds of IP rights that we have, with copyright, there is not a requirement for formality. And this is like an international copyright framework. On the face of it, in certain jurisdictions is different, to be fair. But in Africa, a majority of African countries do not require formality. What this means is that copyright exists just from the existence of the work, right? So what it means is once you have put your work together and you have affixed your work on some kind of medium. The reason people usually get confused as to when we say there is no formality and then we say you need to fix. But the reason why I think it's common sense is that we are saying that copyright does not protect your idea. So for us to be able to protect something, we have to see it. You must have expressed that idea somehow. Okay. And most times that expression is what we refer to as the fixation. Once that work has been expressed, then it is protected by copyrights. Now, in Nigeria, for example, you then have certain provisions made by the government, like registration of copyrights. But this registration is not necessarily that, it's not that if you don't register, you don't have the right. You already have the right. You're only going to the Copyright Commission to lodge this document, to get some form of document that, just publishes to the public that this right is existing. That is what that registration does for you. So if you have the work and you're interested, which I would always advise, it's always better to have that extra document, because in law, they say first in time. So while the person is trying to prove, you already have a document that is to the public to say, this is my work, I published, I lodged it in at so time. And that is always done at the Copyright Commission or what in the jurisdiction, whatever body or office that deals with copyright. The other one is the trademarks. Trademarks, unlike copyrights, is a registered right. So you can only have those rights when you have registered the mark, and you register in usually the patent and in the trademark office, or in many jurisdictions you have maybe a general intellectual property office. Now these are the places you go to and make your application for trademark, pay the necessary fees, and make sure you keep up with the requirements to use the trademark. That is it for trademark. Sometimes designs come in, it takes the same form. I mentioned a bit earlier that trademark in publishing, one thing we are not taking so serious is branding. And trademark is one of the tools that we use in branding. As a publishing company, you need to pay attention to that. There are certain publishing companies, especially when you look at those that publish comic books or even like books for kids and all of that, their names. When you see them, their names. They also even go further to register their brand. So it's like they're not just registering the trademark, but even like the get up of their books. Like once you see it, you know that this book is Oxford, this dictionary is Oxford, this one is this child's book, okay? And that is one thing that a lot of companies need to start working on gradually through registrations and all of that. So, but for our purpose, I'll leave it to copyright and trademark registrations. Thank you.
Okay. You now outlined succinctly common pitfalls that people, I mean, you mentioned some already in terms of the need, even though if there's no requirement for registration, the need to do some kind of public notification. But what from your experience are some common pitfalls and say publishers or authors could fall into? in the protection of their copyrights.
Thank you very much, Mr. Deji.
In terms of those tests and those requirements.
One thing would be the lack of use. So sometimes, even when they register, they forget to keep up with renewal fees. And before you know it, becomes an issue because you're not using it and it becomes a ground for revocation of the mark. And this is in relation to like trademarks. The other thing is with the authors, I don't know. An idea is an idea until you express it and put it out. But obviously, sometimes you have authors that deal with the issue of perfection. They want things to be perfect so much that even before they bring it out, then somebody else has expressed your idea. And you're thinking, oh, but I thought it first. You thought it first, but you did not express it first. Or maybe you thought you were in the process of expressing it and somebody did it better and put it out there even before you. So sometimes we have all those problems. Many a time in the publishing industry, our problem is from the contractual relationships that we enter into. And I've highlighted not most of them, actually just a few of them a bit earlier. But those contractual clauses in those agreements, they relate the kind of distribution rights and distribution agreements that the publisher is entering into with distribution companies. How are you getting discounts from the distribution companies for the wholesalers, for the retailers? Because then if you're going to try, you need to balance a lot of rights. You're balancing the right that's been entrusted to you by the author, you're balancing your own interests, but you're also balancing the interests of every other person that comes up in the value chain. And so if you do not manage the issues that arise between yourselves. So, like, for example, the discounts that the distributors will be asking for, or wholesalers or retailers will be asking for, you're not able to properly remunerate your authors. Your authors lose confidence in you, and they eventually go sometimes even against the contractual relationship you have to look for greener pastures. There are things that we just need to pay attention to. For example, even things like authorship. Sometimes it's not just one author. How do you manage the rights amongst the authors? Are you getting the real license that you need? Are you commercializing the subsidiary rights that accrue to you? Are you entering into reasonable collaborative schemes? Are you engaging properly with the collective management organizations in the industry? The organizations, are you connecting with them as a company? Are you creating some relevance with your brand? I think the last point I would make for the publishers is there is this neglect of the rights and then the finance department. Sometimes you just have publishers that are going about doing their things. You must have a rights department that focuses a lot. And in your rights department, you then have, some call it rights management department, but then you then have somebody, or at least people, that are focused on the IP rights. And then the finance department that manages a whole lot of the issues that arise in royalties. Like I said, Mr. Deji, this topic is not something that we are able to properly canvass in 1 hour, but I hope that anyone who listens in this time gets an idea of how IP does affect the publishing industry.
Ms. Oyagbako, thank you very much. We do know that besides people need in-depth and specific advice, really should be reaching out to you for some fee. And then, of course, this is the inaugural webinar. In fact, a number of issues have come out of this that are probably going to be topics in themselves in future webinars. And I'm sure Kinex will not, or you'll be gracious to accept Kinex, invitation to also facilitate some of those kind of topics. Okay, yes, let me just recap. Ms. Oyagbako, thank you very much for your time today. And you've been very gracious to exhaust a number of things. You have told us that when you started that in terms of AFCA, of course, we can collect from the entire thing some things that are related to publishing, such as protocol on copyright, things that cover research on the visually impaired, audible books, and of course, production of them, things like cross-border flow of educational and cultural materials, which means that we are basically going to create a continental market of books, educational and cultural products, of which books are very important. So thank you for that. And as I said, as you move on in your research, I'm sure we're going to call on you again to see new things that you discover within that framework. Now, in your overview of IPI, of course, you let us know that it's not just copyright, even though that's the main thing we tend to focus on, and it's the principal one, really. But apart from that, we also have trademark. And as you mentioned, trademark is very important because of the kind of things that people publish. So you are not just publishing words for people to read, you're also looking at merchandising, characters in books, especially because I also know that Africans are beginning to produce speculative fictions, which is where you tend to get a whole lot of characters and all of that. You then take along all sorts of mediums, you create comic books out of them, you can make them into films and all of that. So trademark is really, really very important. So for those publishing those kind of things, as the readers get a hang of some of these characters and the world you are creating, you may want to look at, trademark for protecting the names, the characters, the look, the appearance, and all of that. So thank you for that. You also went on to say, in terms of the challenges, your challenges essentially focus really on contractual issues, people not being able to specify what rights are actually given. People just assume when you say, our publishing contract, the publisher is going to publish me, what rights are really entailed in it. So you need to look at each of those rights. The primary right to publish it as a book first. Also, does it also entail the right to publish it in other forms and other media, audio books, electronic books, translation rights, and then the issue of exclusive and non-exclusive, and also global rights. So authors and publishers should focus on and all of this and determine commercial issues that arise out of those different kinds of rights mentioned to us. And I think that's very, very important. You also mentioned something very important. In this regard, the important thing is that you're talking about the commercial valuation. How, in terms of the emerging publishing market in Nigeria, there are certain actors that are still missing. So author representatives and agents are not here, and those are the ones that tend to have the skill to help negotiate the commercial issues and all of that. And so because of that, we need to make sure that we develop those skills and all of that. And of course, elsewhere in the world, people like that tend to come from the publishing industry so that they know what's happening in publishing and then they can represent authors. Meanwhile, CMOs can also step in, as a kind of, even though their interface between the authors and publishers and the market, but because they also tend to be people who have the technical and commercial skills and all of that, they also are very important within that value chain, for us to develop and to assist other people in terms of valuation, how do you determine valuation, and all of that, and all the commercial issues that come out of that. And it's also very important because in certain kinds of publication like children's books, where both illustration and text almost carry the same weight, it tends to be negotiated. And secondly, in jurisdictions like Nigeria, where there are facilities for public notification, it's also an additional step that you may need to take, at least to notify, so that in case of conflict with any other person claiming in terms of a similar work, you can at least have a public notice that you have given that is prior to whatever anybody else has done. So you mentioned that a lot. And of course, you mentioned trademark, and you mentioned how important it is apart from copyright. So, as I said, this is a beginning. We are going to be having further webinars in the future. And I'm sure that we'll be very happy to call on you. And we hope, Mrs. Onyo Bako, that we will be able to accept our invitation to speak with us again. Thank you very much.
Thank you. I have to say thank you to you, because I feel like you've managed to put it all together, even a lot better than I put it in all the chaotic presentation that I gave you. So thank you so much.
You did a fantastic job, and I was just doing mine. But I'm not the speaker, so I could appear organized. I'm sure you do a better job of summarizing me. So thank you very much. So we call on our viewers, please. This is the inaugural webinar. And if you found this valuable, please let us have your feedback. What do you think we've done well? What can we improve on in the future? What topics do you think relevant to the publishing industry that we should be considering? Please let us know. I'm sure that Kenneth is going to put some link that you'll be able to get a feedback on. And also try and register so that you can get, if mailing list, you can get invitation to future webinar. This is very, very important for the creative industry. What's been missing, and I think Afrexim understands that. That's why they are creating this factory, so that other than getting funding, they also know that we need skill sets, and we are lucky to have people all around the world who share with us as we have today. So thank you very much. thank you to KNEX for inviting me, Onyegbafor, and inviting me to be the moderator of this inaugural session, inaugural in this series of webinars. Thank you, KNEX. Thank you to Afrexit Waipo Tamude in Abuja. Thank you, and see you at the next session. Thank you.